Look, for decades, we have been forced to play a ridiculous game of compliance with federal bureaucrats who think they are above the Constitution. Millions of law-abiding citizens, simply trying to send a package or buy a stamp, have been treated like potential criminals the moment they step onto government property. We've been forced to disarm, rendering ourselves vulnerable in unsecured public spaces, all because some antiquated statutes and arbitrary regulations declared the U.S. Post Office a so-called gun-free zone. This isn't safety, it's an insult to the Second Amendment. But today, that entire scheme just collapsed. A federal judge in Texas, an absolute champion for liberty, delivered a massive victory that didn't just chip away at the anti-gun structure, it tore a hole right through its foundation. This is the ruling the federal government tried desperately to avoid, and it signals a fundamental shift in how the courts view these ridiculous, baseless restrictions. We need to understand the details because this win means everything for the future of our rights. This landmark decision comes out of the U.S. District Court for the Northern District of Texas in the case of Firearms Policy Coalition Inc. v. Bondi, delivered on September 30th, 2025. The man behind the gavel is Chief District Judge Reed O'Connor, a name you should certainly know if you follow Second Amendment victories. Judge O'Connor granted summary judgment to the plaintiffs, which means he found the law was clearly on their side without the need for a full trial. The target of this legal challenge was twofold. First, the general federal statute 18 U.S.C. Section 930A, which broadly bans firearms possession in any federal facility. A federal facility is defined as any building or part of one that is owned or leased by the federal government and where federal employees are regularly present to perform their duties. Post offices, by definition, fall squarely into that category. Second, the challenge targeted the specific egregious 1972 regulation enacted by the United States Postal Service, known as 39 CFR Section 232.1L, which explicitly prohibits the carrying, open or concealed, of firearms and other dangerous weapons on postal property. A violation of this regulation could lead to criminal penalties, including fines or up to 30 days in jail.
Judge O'Connor agreed, declaring that both the federal statute and the USPS regulation are unconstitutional as applied to the possession and carrying of firearms inside an ordinary post office or on the surrounding postal property. This is a massive victory for individual liberty that puts the government on notice. The power of this ruling rests entirely on the foundation established by the Supreme Court in 2022, New York State Rifle and Pistol Association versus Bruen. That decision fundamentally changed the rules of engagement for Second Amendment litigation, imposing a strict text and history standard. Judge O'Connor meticulously followed the Bruen framework. The first step under Bruen is determining whether the conduct in question, carrying a firearm for self-defense, is covered by the plain text of the Second Amendment. The court confirmed unequivocally that it is. Carrying a firearm for self-defense is right at the heart of the Second Amendment. Once that threshold is met, the burden shifts entirely to the government. The government was then required to prove that its prohibition on firearms in post offices is consistent with the nation's historical tradition of firearm regulation. They could not merely assert that the regulation was a good idea or that it served a modern safety goal. They had to demonstrate a historical analog from the founding era, circa 1791. This is where the government's case immediately collapsed. The government essentially tried to shoehorn the 20th century bans into the historical tradition. The restrictions themselves, 18 U.S.C. Section 930A from 1964 and 39 CFP Section 232.1L from 1972, are far too modern to qualify as being consistent with the founding-era understanding of the right. The judge's analysis showed that these modern prohibitions are fundamentally inconsistent with the principles that underpin this nation's regulatory tradition. The government failed spectacularly to carry its burden because the necessary historical analog simply does not exist. The Bruen decision, which requires looking at the historical tradition, has proven to be the crucial legal weapon capable of striking down arbitrary, modern gun control schemes that lack any basis in our national history. The primary defense the government deployed was trying to classify post offices as sensitive places, a carve-out mentioned in the Bruen opinion that generally acknowledges the historical acceptance of banning firearms from certain uniquely critical government venues. The government argued that post offices are comparable to legislative assemblies, polling places, and courthouses, locations historically recognized as central to governmental functions and susceptible to disruption. Judge O'Connor was not fooled by this transparent attempt to invent a new category of restricted location. He unequivocally rejected the notion that an ordinary customer-facing post office rises to the level of a truly sensitive place.
Think about the difference. Courthouses, legislative assemblies, and polling places involve weighty matters of public concern and central government functions where heightened security might be required to ensure the process itself is not influenced or disturbed. But a post office, it is a place where citizens conduct routine tasks, sending letters, picking up packages, and purchasing stamps. While important for public services, the court found it hard to see how post offices provide the same weighty government functions as those traditional sensitive locations. The judge pointed out the critical historical context. Around the founding, some legislatures recognized the unique importance of places like courts and assemblies. They did not, however, ban firearms in all government buildings, nor did they treat the post office with the same level of restriction. The government's sensitive place argument was nothing more than an attempt to invent new gun-free zones wherever they please, without any historical mooring. Brandon Combs, president of the FPC, rightly stated that governments cannot simply ban weapons in unsecured public spaces, full stop, and that the Second Amendment does not permit this arbitrary invention of restricted areas. The court's meticulous dismantling of the sensitive place myth is critical, as it subjects every single state-imposed or federal gun-free zone to the same brutal, history-based scrutiny. One of the most damning pieces of evidence against the government's prohibition came directly from the historical record regarding postal services. The government had to admit that postal carriers and facilities faced violence, robberies, attacks, and even train heists well into the 1800s. This proves the founders and early Congresses were acutely aware of the general societal problem of violence directed toward the Postal Service. So, what was the historical solution? Did the founders ban guns in the post office? Absolutely not. Instead of disarming law-abiding citizens, Congress and local authorities chose to punish the criminals responsible for the violence. Even more striking, the government actively armed its own personnel. By the 1920s, due to the frequency of bandit attacks on railway trains, the Postmaster General authorized and supplied government-issued pistols to railway mail clerks so they could defend themselves and the mail they transported. The contrast could not be clearer. The historical tradition was to arm the defenders, not disarm the population. The government only introduced a broad ban on firearms in federal buildings in 1964 and a specific ban on postal property in 1972. This timeline, nearly 200 years after the Second Amendment was ratified in 1791, is entirely too late to claim consistency with the nation's historical tradition. As Judge O'Connor so succinctly put it, it is hard to envision that the founders would countenance banning firearms in the post office, particularly because they did not do so themselves. The court correctly determined that the government cannot cherry-pick modern historical examples to justify a restriction that was alien to the founding era. Adam Kraut, SAF Executive Director, reiterated this crucial point. There is no historical tradition of banning firearms at post offices, and peaceable Americans should not be forced to relinquish their rights simply to use basic public services. This ruling reinforces the principle that if a law or regulation is a modern invention, it must be struck down under Bruen unless it has a clear historical analog. Faced with the undeniable lack of historical tradition, the government resorted to a desperate last-ditch maneuver. They tried to argue that the Constitution's property clause gave them the authority to impose any rules they wished on property they owned or leased. Essentially, they tried to claim that the federal government acts as a private landlord when it operates a post office, and therefore the Second Amendment rights magically stop at the door. Judge O'Connor saw right through this Hail Mary attempt. He decisively rejected the idea that the government, simply by virtue of its property ownership, could bypass parts of the Constitution it deems unfavorable. The government is not a private citizen. It is a state actor bound by the entire Constitution, including the Bill of Rights. This rejection is hugely significant because it prevents the federal government from creating an unconstitutional loophole that would allow it to declare millions of square feet of federal land and the facilities built upon it as constitutionally exempt from the Second Amendment. The court established that firearms restrictions affecting government property are subject to the exact same historical inquiry required by the Bruen test as any other firearms regulation. The Second Amendment does not disappear simply because you are walking onto land owned by Uncle Sam. If the court had allowed this property ownership argument to stand, the federal government could have potentially declared nearly any building or land it controls, from parks to office buildings, a gun-free zone, regardless of history or tradition. By shutting down this property-based carve-out, Judge O'Connor ensured that federal power remains tethered to constitutional limitations. This decision confirms that the right to self-defense is fundamental and travels with the peaceable citizen whether they are on private land, public roads, or even in a building owned by the United States Postal Service. While this ruling is a profound legal victory, its immediate practical application requires crucial clarification. Judge O'Connor issued a permanent injunction, but this relief is as applied. This means the government is blocked from enforcing the unconstitutional ban against the named individual plaintiffs and the current members of the two organizations involved, the Firearms Policy Coalition, FPC, and the Second Amendment Foundation, SAF. Crucially, this ruling does not automatically make it legal for every single American to carry a firearm in their local post office. If you are not a member of FPC or SAF, the federal statute and USPS regulation technically remain in effect for you, and you could still be charged if you carry in a post office. The legally conservative advice, as always, is to stay the course until broader nationwide relief is issued, either through appeal or new legislation. This limited scope underscores the critical importance of supporting these organizations as their victories directly shield their members.
The fight, of course, is far from over. The government will most certainly appeal this ruling, likely sending it up to the Fifth Circuit. However, the reasoning, based on the lack of historical tradition, is now established in this district court and will put immense pressure on other circuits. This decision is already part of a larger trend, following an earlier ruling, United States v. Ayala, where a Florida judge ruled the same law unconstitutional as applied to a postal worker, an appeal the Department of Justice later dismissed. The broader implications are immense. This ruling sets up a potential domino effect. It forces federal courts to subject every location declared a gun-free zone, whether in federal buildings, state-imposed sensitive places, or local restrictions, to the same rigorous, history-based scrutiny. In related legal news, the Supreme Court has also agreed to take up Carrilero v. Bondi, a challenge to a California law that makes carrying a firearm on private property illegal by default unless the owner grants express permission. This law, along with similar legislation in New York that the Second Circuit recently found unconstitutional, was enacted specifically to undermine the Bruen decision by heavily restricting where permit holders could carry.
A decision in Corollero, expected next summer, could further cement the right to self-defense in transitional and everyday spaces. Furthermore, while Judge O'Connor delivered this massive win, a separate federal judge in Texas, Judge Mark Pittman, recently upheld Congress's restrictions on interstate gun sales. This ruling requires buyers to purchase handguns through licensed dealers in their own state rather than across state lines. The FPC called this decision judicial abdication, arguing that the right to keep arms inherently includes the right to acquire them freely. This contrast highlights that the legal battles are complex and multifaceted, requiring constant vigilance and support for organizations that continue the fight in multiple arenas. Victories like the post office ruling give us tremendous momentum, but the war for our rights continues on every front. This ruling in Firearms Policy Coalition Inc. v. Bondi serves as a thunderous declaration. The federal government cannot simply wave away our rights with the stamp of federal property. The court rightfully exposed the arbitrary modern nature of these post office bans, proving they have no basis in the nation's historical tradition. This is a massive legal step toward crushing the myth of the gun-free zone wherever it rears its unconstitutional head, reaffirming that the right to self-defense is fundamental and universal. Support the organizations that make these victories possible, stay vigilant, and never forget that we are the militia.